Good afternoon, everybody. Thank you for coming for our seminar. This seminar is organized together by well-known local firm Al-Tamimi. It's one of the best firms in the region, and a small Russian firm, KK&P, Group of Kolatilov and Partners from Moscow. And so first I introduce the panelists. On my right, my partner Nikolai Pokrishkin from KK&P. On my left, Igor Gorchakov. He's a dispute resolution partner of Al-Tamimi. And Oleg Kolatilov, my partner from KK&P. And the topic is, on one hand, quite oftenly spoken on this kind of conferences. That's about Lugovoy law and relevant cases in Russia and in the world. But on the other hand, so what are we going to talk about today is the impact of these Russian cases for foreign jurisdictions, so for countries in this region and Europe and worldwide. Well, everybody knows about this famous Google case, where a Russian court imposed a fine against Google, and the amount of fine, I even don't know the word for this amount. It's like about 30 zeros. And so most of people think it's funny, this kind of judgments. But the fact is, it's not funny anymore. Because you've heard that like a month ago, a High Court of South Africa, they frozen all Google assets in South Africa. And what jurisdiction next? Yeah, maybe Emirates, maybe China. Well, Russia has quite a lot of friendly countries, or at least neutral countries. So we are going to talk about these funny stories. First, I'd like to pass the floor to Oleg Kolatilov. To give you just a very brief overview of what's going on in Russian courts right now with regard to the Lugovoy law.
Yeah, so before we start analyzing the impact of Russian litigation on foreign proceedings, we should first briefly discuss the ways of how you can get to Russian court. So actually, as you probably know, in 2020, Lugovoy law was introduced, which which includes additional grounds for jurisdiction of Russian courts. So the situations where the Russian court get jurisdiction where previously they didn't have the jurisdiction. And there were two main groups of cases where the Russian court received jurisdiction according to Lugovoy law. So these are the cases involving sanctioned persons and cases following from sanctions. So cases based on sanctions. So the first group of cases involve, as I told, involves cases involving sanctioned persons. So these may be any persons. So these may be Russian persons. These may be foreign persons from any country. These may be any sanctions except Russian sanctions. Most notably, this may be Ukrainian sanctions, because Ukraine has a very vast sanction program. So Ukraine has sanctioned much more people and companies than foreign countries. So, this right of sanctioned persons to litigate in Russian courts applies even if the dispute has no connection with sanctions, and even if the dispute does not affect the dispute resolution procedure. So the only limitations is that this should be Russian-related sanctions. So any sanctioned person affected by sanctioned by Russian-related sanctions may bring the case to Russian court. And so the second category are the cases following from sanctions. And most notably that these grounds apply also to the cases where you have the dispute resolution clause, where you have the arbitration clause, or where you have the prorogation clause. So despite these clauses providing for jurisdiction of some non-Russian court or arbitration, you are allowed, according to the law, to break these clauses and to bring the dispute to the Russian court. The only reservation here is that the sanctions, if you have a clause, the sanctions should prevent access to justice, and in this case the Russian court would deem that prorogation clause or arbitration clause unenforceable, and that would be a basis for the Russian court to take jurisdiction despite this clause. What these obstacles can be? For instance, it's impossibility to make payments regarding to the dispute resolution procedure outside of Russia. So it's the situation when some law firms refuse to take assignments. These limited visa availability, so limited travel options, and also the risk that the foreign court or foreign arbitration would apply sanctions, which is considered by Russian court as a limitation of access to fair justice. So, and there is also the position that these obstacles, they shouldn't be absolute. So there may be some obstacles, and proving some obstacles may be a ground for the Russian court to take jurisdiction despite arbitration clause or despite prorogation clause. And most importantly, Lugovoy law cannot be waived. So you cannot write in your dispute resolution clause that, well, we agree, we know the sanctions, we agree for the jurisdiction of some foreign arbitration or foreign court. So, well, technically you can write it, but it will be ignored by the Russian courts. And also in non-friendly countries, so in the countries that apply sanctions against Russia, the access to justice is deemed to be limited. In this respect, for establishing jurisdiction of Russian court, there is actually no difference whether you have not the arbitration or prorogation clause, because now the courts presume that the access to jurisdiction is limited. And even in friendly jurisdiction, you can prove that you have limitations on access to justice. For instance, you cannot make payment and so on. And next I would like to discuss the situation of how you can find yourself in a Russian court. So for instance, you are the company in the United Arab Emirates, and you have concluded a ordinary sale and purchase agreement with some maybe even Western country, so with a company from some Western country, from a non-Russian company. So how you can still find yourself in a Russian court? For instance, this company may be purchased by a sanctioned company or individual. Or some sanctioned company or individual may get control of that company in a way other than purchasing that company. That company may be sanctioned by Russian-related sanctions. For instance, it is established that that company makes deliveries to Russia. It may be sanctioned, and you, having concluded, Emirati firm having concluded a contract with a non-Russian firm, due to the sanctions can find itself in a Russian court. The contract itself may be affected by Russian sanctions. For instance, if it's sale and purchase agreement and the transit comes through Russia, and for instance, the transit becomes impossible due to Russian sanctions, even if you're an American company and your seller is from Western country, still the contract is deemed affected by sanctions, and that is a ground to establish the jurisdiction of Russian court. And one more possible way is a situation when the payment is affected by sanctions. And if your dispute arises from the failed payment, this may also be qualified as a case following from sanctions and be a basis to establish jurisdiction of a Russian court. And we have vast statistics of applying the Lugovoy law. So these are several hundred cases a year. So there are around 400 cases in 2024 and 350 cases for the first half of 2025. So the number of the cases is increasing, and usually they are for a very significant term. And apart from departing from the dispute resolution clause agreed by the party, Russian courts also practice ignoring the choice of law clause. They do it by the following way. So they qualify, so the claimants, they qualify the claims, which are actually contractual claims, they qualify it as tort claims. And when qualifying them as tort claims, they also claim that the consequences of the tort occurred in Russia. So it applies mostly to Russian parties. And the consequences of the tort having occurred in Russia is interpreted by, wrongly interpreted by the court as a ground to apply Russian law, thus departing from the law initially agreed by the parties. So this means that you may unexpectedly find yourself in a Russian court on a ground of which you didn't know, and on the ground which and that would not qualify as submission to jurisdiction, because before pleading on the merits you have already made a reservation that you don't recognize the jurisdiction, and you can also appeal the judgments on the basis of lack of jurisdiction, despite you have pleaded on the merits. And also, when pleading on the merits, you'd be able to present all your arguments, and if they are not accepted, depending on the jurisdiction of enforcement, you can plead that the public policy of the country of enforcement was breached, so the judgment should not be enforced, or there was no fair trial, or that the parties were treated unequally. And you can oppose enforcement by making all these arguments. But to do this more effectively, you should first state all these arguments in Russian courts. And also, depending on your contractual framework, you may even be obliged to defend yourself in the proceedings. For instance, for the purposes of recovering insurance, because a lot of insurance contracts say that you should dispute all claims, or for instance, for the purposes of recourse, or if there is some other contractual ground effectively obliging you to defend your case.
Hello, everybody. Thank you, Oleg. I will add that presenting of the detailed arguments on merits of the case in Russian proceedings may be aimed not only at persuading the court, Russian court itself, but at provoking the Russian court to disclose the political motivation of the judgment. Since in case when there are no objections on merits, it's quite easy for the Russian court to say that the case was presented by the claimant, no objected were presented, and with a couple of paragraphs come to conclusion. But when the detailed breakdown of the counter arguments is presented by the defendant, the Russian court has to either rebut them in detail and consider those arguments in the decision, and usually the court has no purely legal arguments in this respect. Usually the court has to refer to the political arguments, to the sanctions as it is, or the court has to omit mentioning the arguments of the parties. And I think that the most interesting question in this respect is whether such breach of the material law by the Russian state court may be a ground for recognition or for refusal to recognize and enforce this judgment abroad. In some countries, it may be qualified as breach of public policy. There are different approaches in this respect: the broad public policy or narrow public policy of the country. And in particular, since we are in UAE, I will ask Igor about this and about qualification of such material mistakes of the Russian court in the context of recognition of the judgment here.
Yes, please, Igor. So most interesting yeah, just to understand well, if a Russian judgment creditor would bring a Russian judgment to this country and try to recognize and enforce it. I mean, not just a Russian judgment, but a Russian judgment based on the Lugovoy law. So what do you think if there are any prospects to succeed?
Yeah, thank you, Maxim. Good afternoon, everyone. Well, that's quite a big topic, frankly speaking. I mean, we can speak the next 2 hours just about that. So I'll try to highlight just the most important issues to be taken into account, because as Maxim rightly said, first of all, there are quite a lot of these Russian judgments at the moment. I've read statistics. Well, last time I read it like 8 months ago, and by that time there were more than 500 reported cases by Russian companies against international defendants. And if you take the combined quantum of these cases, even if we exclude this the Google case, which I think the quantum is 2 times more than the GDP of the whole world. But if we take the quantum of all other cases, it is quite significant, and it is clear that these defendants do not have that many assets in Russia to satisfy these claims. And the question arises, where would they have these assets? And if you look at this particular jurisdiction, you will find quite a lot of these Russian judgment debtors operating in this jurisdiction. And quite often, you will see the very same companies that operate here, for example, as branches, that are being subject to these Russian judgments. So hence, that's where we have these risks coming from. And speaking about UAE, it's a very interesting jurisdiction. You know, we have, like, in the court system of this country, we have 3 layers of courts, different courts. We have onshore courts, and we have courts in 2 financial free zones, DIFC and ADGM. And all these courts have different rules. That gives potential Russian creditor a certain choice as to what kind of course of action they can take in order to try to enforce their judgment. So if we start with the onshore courts, well, first of all, it's quite a known fact that there is no treaty in place between the Russian Federation and the UAE dealing with recognition of civil court judgments. But this is not per se an obstacle for enforcing a Russian judgment in onshore courts in the UAE. The first requirement or the first gateway here to satisfy would be proving a reciprocity between Russia and the UAE for enforcement of civil court judgments. And onshore courts, they use what we can call a civil law test, where the reciprocity needs to be proven, i.e. that you need to demonstrate that Russian courts really did enforce the judgments of the courts in UAE. And this day, it is possible to do so. About a year ago, quite conveniently, Russian commercial courts in one of the southern regions in Russia enforced at least 2 judgments of the courts of Dubai. So we have this reciprocity in place, at least. So the first gateway can be satisfied or can be passed. And there was also an unreported case where, as far as I heard, courts in Dubai also enforced the judgments of the Russian courts, but not commercial courts. These were the courts of a general jurisdiction. But still, I think that can be used as as a proof of the reciprocity. So then you have pretty standard gateways that needs to be satisfied, and first of all, the judgment enforcement of which is sought must be delivered by a competent court. Here we come to the discussions of the points that were raised by Nikolai and Oleg before. And the onshore courts will need to be demonstrated that judgments delivered by the Russian courts, if you seek the enforcement of them, were actually enforced by the competent court, and the Russian court has a competence to deliver them. That will be very interesting discussion, how that interplays with the breach of arbitration or jurisdiction agreement by that judgment. Also, there are a number of procedural requirements, but they're quite important. Particularly, you will need to demonstrate that your judgment debtor was properly notified or served the process and was properly represented. The question of service, I think it's another topic which we can spend 2 hours discussing, in particular the practice of the Russian courts of serving the process on the foreign parties, which is not often quite consistent what the law and the relevant international convention require. Finally, the judgment, the enforcement of which is sought, first should not contradict any judgment of a UAE court. And I suggest that we keep that in mind, because we come back to this discussion, to this point when we will be discussing anti-suit injunctions and their enforcement here. And it shouldn't also contradict the public policy here in the UAE. Well, public policy, again, is another topic which we can spend half a day debating what it is particularly, and how it is construed, interpreted, and applied here by the UAE courts. I should say that normally it's probably the weakest argument that a party defending an enforcement is raising. If you have nothing to say, go for a public policy. But speaking about onshore courts in particular, we should bear in mind that we are in a Muslim country, and for example, if the judgment which you seek to enforce is not compatible with Sharia principle, for example, provides for an exorbitant interest to be charged on your judged debtor, this is where you can raise and you can start a discussion on a public policy defense in the onshore UAE courts. And now, but as I said, the UAE operates several court systems, and if we go now to DIFC courts, which are common law courts, they use a different test for reciprocity. It's a common law test, and you don't need to specifically prove that there were cases when DIFC court judgments were enforced in Russia. That will be sufficient to demonstrate that Russian court never refused to enforce the judgments of DIFC court. There are also a number of requirements in the DIFC law on to the judgment that you're seeking to enforce. One of the issues that will be discussed for sure, the one that Maxim mentioned, as to whether the judgment debtor submitted to the jurisdiction of the court. And here I've, again, sorry for repeating myself, it's another topic which we can discuss half a day, as to what kind of principles of submission will be used by DIFC courts. Will this be the Russian principles that are used by the Russian courts, or will DIFC courts will use its principles, or the principles that are used in common law generally, to determine this matter? Well, speaking about, if we speak about common law principles of submission, you can find them in Dicey and Morris, and they're very wide. Any filing of any defense, that's, if you read Dicey and Morris, what you see there, that filing any defense may amount to the submission to the jurisdiction. However, speaking about practical application of this principle, if you did it on or with reservation of your rights, and which was quite express, that you don't accept the jurisdiction and you challenge the jurisdiction of the court, I don't think that it will be a very, very easy task to persuade the DFC court to accept it as a submission. But again, this is the issue that will need to be debated in the court. So every time it raises a lot of questions. Also, at DIFC courts, they also do have this ground as public policy, but there's one more interesting ground there that I would like to draw your attention to, which is that DIFC court may refuse to recognize and enforce a foreign court judgment if DIFC court finds that the manner in which the judgment was delivered goes against the principle of the natural justice. And this is a very interesting question, which is not only a question of a pure procedure. It's basically a question of whether the rights of the relevant foreign defendant in the Russian proceedings were observed. And quite often I hear a question, well, when determining this matter, would DIFC court compare the procedure that was held in these particular proceedings with the procedural requirements of the Russian court and see whether they have breached the procedure of the Russian court, or will there be something else? Now, what is quite important, the DIFC court here will look at the proceedings at the Russian court from a standpoint of its standards of the natural justice. Again, it will be quite difficult to say now how it will work in the DIFC court. If you want to see how it works in the common law courts, and in particular English courts, I would refer you to quite a famous recent case of Zephyrus Aviation Partners, which was, I would say, a pretty outstanding case where the English court refused to uphold the jurisdiction agreement in the insurance contract, referring a dispute under this contract to the Russian courts by basically reviewing the procedure that is employed by the Russian courts and Russian judges vis-a-vis defendants from so-called unfriendly countries, and particular from UK, and to see whether the proceedings there will meet the justice standards that are employed by English courts. I would tend to think that the judges in any common law courts would use the same tests and the same approach. And I think that that would be an arguable defense for any judgment debtor vis-a-vis Russian court judgment against it, to refer the DIFC court to this particular case. But again, it's very difficult to speak about that in theory. I mean, this is the matter which is very fact intensive. so that you will need to look at particular proceedings and what specifically happened in particular proceedings where a Russian court delivered a judgment. But at least you have here a defense instrument or a defense gateway, whatever you call it, against such legal judgment.
Thank you, Igor. So, of course, well, it's from case to case, but say if we imagine that, well, definitely the jurisdiction based only on Lugaway law, because say the parties has like, I don't know, DIAC Dubai arbitration clause, and Russian party brought claim in Russian court, and so the defendant clearly challenge jurisdiction, and that's it. So, for example, challenge jurisdiction, and then Russian courts still admit its jurisdiction. So, what do you think if just this fact of challenging the jurisdiction would be enough not to recognize and enforce such Russian judgment?
It's a very good question, Maxim. Well, as I say, will not be trying to predict what ADIFC court will say, but what I can say for sure that there will be at least an arguable defense here.
I see. Thank you. Yeah, because what I see so far, they have no enforced Russian judgments based on the Lugaway law. Well, I'm aware of about a dozen proceedings started worldwide. Mostly that's about a Google case. So we brought applications in Serbia, Egypt, Kazakhstan, South Africa, and some other countries. And so all these proceedings are still pending. Only in South Africa, some partly success. Yeah, so the cases are frozen, but the judgment is still not recognized yet. So we will see. So in here, what I see, in Kazakhstan, at least the application failed in that was RusChemAlliance case. So the first instance court and the appeal court of Kazakhstan, they denied this recognition, but on quite vague reasons. So again, there is no full stop in this story. So I believe that the main threat and the main difficulty in such proceedings is that what would be the ground for denial of recognition? Yeah, because in most countries it's a breach of public policy, and application by a Russian court of the Lugaway law, is it in a breach of, say, Chinese public policy, or I don't know, South African public policy, or Indian public policy? That's a big question. Yeah, because most likely not. Because if it's like exclusive, for example, jurisdiction of English courts, and the Russian court accepted its jurisdiction, and then such judgment is brought to England for recognition, that would be definitely denied because of breach maybe of English public policy, because English courts had exclusive jurisdiction. But if such judgment brought to another jurisdiction, so there is a big threat that just no grounds to deny its recognition. And the second one, you, Nikolai, already mentioned, so maybe, and you, Igor, mentioned like unfair trial or a breach of natural justice. So for this one, so maybe it's just a challenge of jurisdiction is not enough. So when you should show that you dispute on the merits, and the Russian court just ignored all your arguments. So this might be deemed as a breach of natural justice or unfair trial, yeah, because Russian court treated you as nothing. So we will see. But my next question, so just like 3 weeks ago, I saw very interesting Russian court ruling that's again linked to Google case, and you know, Russian subsidiary of Google went bankrupt, and its manager now acting on behalf of Google, and the manager brought several claims to challenge Google transactions. And so these proceedings are within the bankruptcy framework, not Lugovoi law. And so I pass the floor to Nikolai, to view this situation from bankruptcy proceedings. So if the threat is even higher.
In brief, yes, indeed, it's definitely higher. And I will divide two situations: the insolvency of the Russian subsidiary of the foreign company and insolvency of the foreign company itself in Russia. The first case is quite well predicted and well expected by the foreign companies having such subsidiaries in Russia, since for the previous years most of them made significant steps to stop any business activity in Russia, and eventually it should lead to insolvency of these entities. So I will not pay too much attention to the insolvency of Russian subsidiaries, but I will highlight just 2 points in this respect. First of all, we should not expect that the consequences of such subsidiary insolvency would relate to Russia only. So it's quite acceptable for the many of the foreign companies that their Russian assets and assets of their Russian companies will be distributed between the creditors, but it's not the end of the story, because the second stage of this story is the recognition and enforcement of the judgment from the Russian insolvency proceedings abroad. And those judgments may be issued not against the Russian subsidiary itself. It may be issued against the counterparties, against the management, against beneficiaries, shareholders of the Russian subsidiary. And those judgments may be enforced abroad, like Google case, where in October the judgment on dividend payment challenge were recognized in the amount of $120 million. So it's the scope of consequences of the Russian subsidiary insolvency is not the Russia only. It may be enforced abroad. And the second trend nowadays is attempts of the Russian receiver of Russian subsidiaries to challenge transactions with the management and employees of the debtors. And we see that a lot of foreign companies, I will say, try to protect their former employees and their management, not only because of the ethical considerations, but because of the, I will say, significant value of the staff for the evidence and further development of insolvency proceedings. So, talking about the less expected topic about insolvency of the foreign companies themselves in Russia, I will just say about 3 main things. First of all, insolvency of the UAE or European or US company in Russia is a kind of lottery. However, you may affect the outcome of a draw. What do I mean? A lot of foreign companies has already bought a ticket for this lottery, because the test for introduction of the secondary insolvency proceedings is very broad. I will say that the primary insolvency proceedings are possible as well in case no defenses were provided by the foreign debtor in Russia. But the most likely outcome is introduction of the secondary insolvency proceedings. The problem is that there is no any statutory or codified law in this respect. There is no detailed and verified test for introduction of the secondary proceedings. So this mechanism, I will say, appeared just less than 2 years ago. It was 8 February of 2024 when the Supreme Court issued the ruling on Westwall case. So basically, the whole option of recognition of the foreign company insolvent in Russia is based on one high court ruling, which means that the test mentioned in this ruling is quite broad, and there are different examples of what may be considered by the Russian courts as close connection to Russia and be a ground for secondary insolvency proceedings. Just for example, if the company performs an economic activity in Russia, what does it mean, economic activity? It's a very good question for dispute. If the commercial activity of the company is aimed at Russian residents, it's maybe company located abroad, for example, IT company, but its activities is aimed inter alia to Russian residents, and this may be a ground for the secondary insolvency proceedings. If the company has a managing body or a branch in Russia, if the company owns property in Russia, including the property rights. So we are not saying that the movables or shares should be held. It's fine to have just the right of claim to the debtor in Russia, and this may be a sufficient ground to start the insolvency proceedings. So in practice, we see that there are several hundreds cases initiated for the last 2 years for insolvency of foreign companies in Russia. More than half of these cases were initiated by the Russian tax authority. So the state is practicing, the state is testing this mechanism. The state is checking what is possible within this mechanism. And we see that the court generally tend to introduce and to satisfy such motions. Sometimes the only connection, as I mentioned, is just the right of claim of the foreign company to the Russian debtor for a considerably small amount, and it was sufficient to recognize the company insolvent. I will especially note that the Supreme Court highlighted that the burden of proof is mainly on the debtor in such cases. So it's fine for the claimant to generally show that there is somehow connection between the debtor and between the claimant, between the debtor and Russia, and it's the debtor's burden to provide the full proof of the absence of such connection. So a lot of foreign companies ignored such Russian proceedings. Most of them didn't even know about the start of such proceedings, which was sufficient for the Russian court to say that no, any objections were provided. Notification, as Igor mentioned today, is not a strong part of the Russian legal system, I would say. And most of these companies were not notified about those proceedings. Also, we calculated that in 75% of cases, there were no public announcement about the start of insolvency proceedings. So there is a court database, and you should carefully check whether there is a line about filing of the motion. And what does it mean? It means that in case the foreign company missed opportunity to present the defense, then most likely the court will apply at least secondary insolvency proceedings. However, we see the examples when the foreign company is successfully defended. For example, Credit Suisse, which actually has quite significant assets for billion rubles in Russia, successfully protected itself from starting of the secondary proceedings because of the active and good presentation of arguments. So this is a lottery, and you may miss the draw in this lottery. But if you present your position, it's quite possible to protect yourself from the Russian insolvency. So this was the first point. The second point, that insolvency in Russia may start sooner than you expected, because by default, you may expect that insolvency proceedings will start after the long litigation proceedings on recovery from the foreign company. So the creditor will get the judgment on recovery, and only then the creditor will start insolvency proceedings on the basis of this judgment. It's not true. Or it's not an absolute true. Thus, if the creditor or the foreign debtor is a Russian bank, or the creditor of the foreign debtor is the Russian tax authority, then those bodies, under some conditions, may start insolvency proceedings without getting the prior recovery judgment. So you may just have an obligation before the Russian bank out of credit agreement or before the tax authority, and there will be no any pretrial procedure in this respect, no any litigation on recovery of money from the debtor, they are allowed to start insolvency proceedings as a first step of their activity against the debtor. And this is quite a big issue. We see that this trend is just appearing. We found one case when this was accepted by the court. We found one case when the court dismissed these arguments, but at least this is a quite significant risk that banks or tax authority will start instead proceedings without any preparation steps in this respect. And what does it mean? It means that the foreign debtor will not have enough time to collect information and present good, well-grounded position to object introduction of the secondary insolvency proceedings, because it's quite short period, 1 month, usually 1 month, between appointment of the hearing and consideration of this issue. So from the practical perspective, if you have a creditor like a Russian bank or a Russian tax authority, I will strongly recommend to collect the evidence and arguments objecting the grounds to start insolvency proceedings in advance, not waiting for the filing of the motion. And the third last point in this respect is that, once again, consequences of the Russian insolvency proceedings are not limited by the territory of Russia, even in case of the secondary insolvency proceedings. I understand the concept that primary proceedings are usually considered as worldwide effective, while the secondary insolvency proceedings are usually associated with the effect only within the territory of the secondary insolvency proceedings. But in fact, when we're talking about Russian secondary insolvency proceedings, it's quite possible that the judgment on challenging of transactions may be recognized abroad. We talked about it earlier. And also the damages tort claim against the management and shareholders may be recognized abroad as well. And there are two issues in this respect. When we're talking about challenging of transactions, we should understand that in Russian insolvency cases, those not only the contracts, the performance of the transactions may be considered and challenged as well. For example, the payment under the contract may be itself considered as a transaction. Economical consequences of this transaction may be assessed, and this payment may be challenged, like payment of dividends in the particular Google case. And the second point is that the tort liability damages for the management and shareholders for insolvency of the foreign company is quite not, I will say, not discovered area of current Russian case law, because there are just first motions filed in this respect in several cases, and there is no exact test. But we expect that the companies who left Russia intentionally, and most of the Western companies, of course, made some decisions in this respect. They made some announcements in this respect. Most of them clearly tried to withdraw itself in assets from Russia. So these steps aimed at stopping economical activities in Russia may be considered as actions which actually led to insolvency of the company, insolvency of its property estate in Russia, which is quite a big risk. The problem with those insolvency judgments is that they are based on a, I would say, natural jurisdiction for the insolvency cases. Because when we're talking about Lugovoy law, it's quite clear that there is a direct breach of the DR clause, arbitration agreement or prorogation agreement, by the very specific and politically affected Lugovoy law, and attempts of the Russian claimants to rely on this. But when we're talking about the insolvency, the problem is that generally the insolvency is a natural way to bypass the arbitration agreement. In the most countries in the world, it's quite direct rules that arbitration agreements, prorogation agreements may be ignored in case of insolvency, because the claims should be considered all together in the same case, and it's quite normal. So the same creditor, which initially had to file the claim under the Lugovoy law in order to go to Russian court, he may avoid this and file the claim on the basis of the insolvency rules. And in such a case, it will be not a ground as a politically affected Lugovoy law. It will be normal recognized all over the world ground, like an insolvency proceeding, secondary insolvency proceeding. So this may be considered as another way to avoid the risk with recognition of such judgments abroad. And another risk, which is not discussed yet, and generally I didn't hear about this at this conference, maybe I missed it, is that even the receiver appointed in the secondary insolvency proceedings may try to claim some rights for the assets outside of Russia. Formally, of course, his rights relate to the assets within the territory of Russia only. But he may argue that some particular assets were transferred from Russia outside, and those assets initially were aimed to be used for satisfaction of the foreign company within Russia, and that's why the receiver has a right to come, for example, here in UAE and say that, look, those assets are located here, but actually those are Russian assets, and that's why I have some powers over those assets, and then file the respective claim for foreclosure or similar claims. So what I'm trying to say is that, first of all, that the threat is quite real. Second, you should be prepared in advance, because it's quite possible that you will not have enough time to present the position when it starts going. And the third point is that it will be really nice to consider in what particular jurisdictions the judgment will be potentially recognized, in order to assess the local rules on recognition and to assess what kind of defenses should be presented before the Russian court in order to prevent the potential subsequent recognition abroad.
Thank you, Nikolai. So let's make a small research right now. So, for example, you see that there are two grounds to recognize the Russian judgment abroad, relevant to our topic today. So the first one, that was like Lugovoi law. That's why Russian courts accepted its jurisdiction. Or alternative ground, it is just bankruptcy proceedings. And that's why Russian court has exclusive jurisdiction over a bankruptcy case. So if you are a judge in your jurisdiction, so if Russian judgment was based on Lugovoi law, would you recognize this judgment? So please raise your hand if you recognize it. What jurisdiction? All right. Okay. Please take my mic.
I'm not of the opinion that it should be in all cases unlawful, in a nutshell. So I'm coming from Europe, as you know, so in our jurisdiction, there is no way to get this recognized. So, but in principle, I think, I won't say 100% it is unlawful per se, but it's my personal opinion.
Thank you. Okay, and let's now imagine that the case, like the second scenario, when it started with the Lugovoi law, and then it led to bankruptcy of foreign company's subsidiary in Russia, for example, or foreign company itself in Russia, yeah, because there are some links to Russia. And so it's a judgment brought in a bankruptcy case, and then it's the judgment creditor is trying to recognize and enforce it abroad. So you are a judge in your jurisdiction. Would you recognize this judgment? Please raise your hand who recognize it.
Well, I have different things. I've just been hearing. My name is Abdurrahman al-Sharia. You can call me Abdel. Oleg, Igor, Maxim, and Nikolai. You've been saying challenging jurisdiction and court, the Russian court claiming jurisdiction, non-friendly countries. And I think the solution is political, not legal. So you've already asking rhetorical questions which you already know the answer for. The solution is political, and I think you don't need to wait for the reciprocity that you mentioned. Signing judicial cooperation treaties with countries where you want to execute the Russian judgments is the solution for whatever you're facing right now. I think also if you are talking about foreign companies leaving Russia or having issues with doing business with Russian companies, you forgot the hostile takeover of McDonald's in Russia. I don't know what is the name now, but it's Tasty and that's it, something like this.
Tasty and full stop.
Exactly. Yeah. So you can't claim that you are the underdog here because you've done whatever possible you can do in Russia when it comes to foreign investors. But in order to fix or trying to help or finding a creative solution for what you've been facing, whether you want to execute Russian judgments against Google in Egypt, South Africa, or whatever, I think you need to have a meeting with the Ministry of Justice in Russia, like the top law firms will go there, have a meeting, and try to discuss these judicial cooperation treaties with countries where you want to execute your judgments. Better than advising your clients to change the ultimate beneficial owner. So we don't need to have the nationality of the company. It's a Russian company, but for example, having the ultimate beneficial owner will be Russian. However, the company is registered in Panama. So Panama is neutral, so you can use this in your favor. Somehow, these are types of ideas or solutions for your situation, but you already know the answer. It's political.
Thank you very much for your feedback. Just 2 comments in this respect. First of all, we are focusing on representing of the foreign clients in Russia and abroad. So it will be quite strange to suggest our clients to have a meeting with the Ministry of Justice of Russia and discuss those issues. The second point is that, of course, the eventual and ideal solution for all of this stuff is some treaties, but it may be quite hard to motivate public bodies to conclude any treaties. So we have to face the reality as it is, and we have to find the solutions for our clients, and we have to consider the potential threats for our clients abroad, not only in Russia, but here in UAE as well. And that's what we're talking about here now.
Yeah, and well, the treaties, it takes like ages, to ratify any international treaties, and the situation is developing rapidly and right now, so there is no time to wait. Sorry, you had a question.
Yes, thank you very much. Just an additional comment, and maybe this helps a little bit to understand the answer to the previous question from my perspective. Anna Zeitlinger, Lansky, Ganska and partner from Vienna, an international law firm with a headquarters in Europe. From our perspective, we're looking at this matter because we are sitting a little bit on a different side of the barricades from what your colleague just said. We sit in a situation where we defend the interests of the Russian companies in Europe who are facing expropriation. And the situation that we are seeing right now is that Europe is, I won't say full of piggy box, but it's quite substantially. In each country of the European Union, there are some remainings of assets of Russian companies hostilely taken over by the government, taken under administration, or forcibly sold to other local players. So we have the state who has benefited from the situation. We have local measures taken in access to the European law, and we have local parties who benefited and has taken over the assets of Russian companies. So this is a different situation. And we have the shareholders and mother companies sitting in Russia still and observing the situation from abroad, having no possibility to impact. And of course, considering this different perspective, you can see Lugovoy law and the other options and opportunities provided by the Russian legislator as a hostile act, of course, towards the European companies, because certainly it provides a certain means to make it unjust in another way. At the same time, for some companies, it provides a counterbalancing possibility and a solution to find a judgment to combat actually the unjust behavior of the European counterparts and the European regulators in turn. And this gives an opportunity in going abroad and then seeking the recovery abroad, be it through the perspective of Lugovoy law, although of course it's now prohibited and penalized under EU regulations, so there are limited opportunities to do so. But the bankruptcy is something which might be a creative approach in my perspective, and maybe a tool to help to seek the recovery through also other jurisdictions. But of course, there are a lot of prerequisites to keep in mind. What I just want to say is that it's not that black and white. It very much depends on what is the perspective of the client you represent. And certainly, there are situations where the judgment should not be recognized because it's unjust and a violation of procedural rights. On the other hand, it's an important counterbalance, and the judge also in other jurisdictions can keep that in mind and consider. I think it's not illegitimate.
Yeah, we are not talking about the politics here, and we are not ready to say that this is black part or this is white part. We are talking about the risks of the particular entities posed by the situation and potential steps to prevent those risks. We are not saying that those companies are good, those companies are bad. And from the practical perspective, I understand your approach. The problem is that I suppose that the courts in UAE as well should not say that the state is equal to the entity from the state, and that behavior of the entity is caused by the state of this entity, and that the entity may be punished for the behavior of its original state. So that's it.
Thank you. Igor, so what do you think about the topic Nikolai mentioned, like insolvency cases, and so any impacts for this jurisdiction?
Well, this jurisdiction will definitely have some traction with that. Again, we need to look at it from the perspective of both offshore and international courts here, onshore and international courts here, because the situation will be very different. Also, speaking about an onshore courts, fortunately or unfortunately, depending on whom you are representing, there will be very, I would say, little room for enforcing Russian insolvency judges in onshore courts, because here there will be an additional complicating element, very technical one. It will be the same requirement for reciprocity, but in that particular case, the reciprocity should concern specifically the enforcement of insolvency judgments and not general civil judgments. There've been a reported case of a Dubai Cassation Court, which I think judgment was delivered about a year ago, which confirmed that position in onshore courts. I'm not personally aware of any UAE insolvency judgments being enforced in Russia, so it will be very difficult to prove reciprocity here. And unfortunately, if you can't do that, that's where your discussion with onshore courts end. However, if we speak about courts in DIFC, the situation will be different. Because DIFC insolvency law is very different from the insolvency law, onshore insolvency law. And speaking about the cooperation with foreign courts, DIFC specifically adopted the ancestral model law on insolvency. So those who practice international insolvency are surely familiar with that. So it's being adopted in its entirety. So it's just the same rules. That's why on the other hand, you at least have an instrument how to do that. Second, speaking about like foreign companies registered in the IFC, if they're registered as branches of respective foreign companies, as a matter of DIFC corporate law, they are deemed to be recognized foreign companies. And as a matter of DIFC insolvency law, you may start an insolvency of a recognized foreign company in DIFC. So there will be two options available to such creditor. The first option is to take the insolvency judgment to DIFC and try to enforce this judgment against a DIFC entity, so-called DIFC entity or company registered in DIFC. Or the second option would be just to try and start the insolvency of a recognized foreign company itself. But speaking about enforcement, the pinch of salt here would be that there will be very difficult jurisdictional gateways to satisfy. And those will be very, very fact intensive. So you will need to look at particular proceedings and the circumstances around that, because I'll give you some examples as to what these jurisdictional gateways are, so that you have some flavor of what kind of issues will be reviewed by the court in that case. Well, first of all, as the DIFC law says, the foreign proceedings that have been commenced, in our case in Russia, is recognized by DIFC courts as having appropriate laws and procedures for dealing with insolvency. So that will be a first very interesting gateway to satisfy, and it will be a very interesting discussion as to whether DIFC court will view the Russian insolvency laws and procedures as appropriate. And speaking about the case that you mentioned, Nikolai, about insolvency of foreign companies in Russia, I mean, it's not a secret that there's no procedure for that type of insolvency in the law. This is something that was invented by the Russian Supreme Court in one of its judgments. So the big question will be if a creditor will bring this type of a judgment, introducing so-called non-main or the secondary insolvency proceedings against foreign company in DIFC. That will be a big question how this gateway will be satisfied, because, you know, I do respect judgments of Russian Supreme Court a lot, but they are not a part of a Russian insolvency law. The second gateway that would need to be satisfied is that these foreign proceedings, in our case the Russian proceedings, are consistent with the principle of natural justice and must not be contrary to the public law in the DIFC. We have discussed that already. Another interesting principle that will need to be satisfied, and another gateway, will be the following: the foreign proceedings should not discriminate against creditors on the grounds of their nationality or the place of residence. Speaking about current state in the Russian insolvency proceedings, where you have creditors from friendly jurisdictions and non-friendly jurisdictions, where non-friendly creditors get all their money to blocked accounts just because they come from a wrong place, from Austria, for example. How would that satisfy this gateway? So there will be a lot of interesting questions to discuss if such matter is brought before a court in DIFC. But as I say, it will be very much fact intensive, and it will very much depend upon the circumstances of a particular case.
Thank you very much, Igor. So let's turn now to Next topic, anti-suit injunctions. You know, at recent 3 years, there is a big battle of anti-suit injunctions. So, like English court, for example, passed down anti-suit injunction, and Russian court anti-suit injunction, and then it's endless battle. And I have here some statistics. So, in Russian courts in 2002. It was brought about 50 applications for anti-suit injunctions. 22, yes, 22. In 23, about 100 applications. In 24, about 120 applications. And for the first half of this year, about 60 applications. So we see the growth of these applications, and I see that the satisfaction rate is quite high. Yeah, like last year, it's about 95% of such applications brought in Russian courts were satisfied. So here we have few issues. So the first issue, to bring such application to a foreign court, what for? So what is the purpose? Because we understand that Russian courts just don't care about foreign injunctions not to continue a Russian case. And in most of the cases, Russian parties also don't care about it. So what we see, however, that sometimes Russian parties, especially big Russian banks who still have some international activities or maybe hopes for international activities, they sometimes comply with foreign anti-suit injunctions. Maybe because, yeah, they really care about negative complications for non-compliance. Maybe they care about their management who still travel around the world, or maybe some other reasons. But it's quite rare, but we see it's maybe in 5–10% of cases where big Russian banks comply with foreign anti-suit injunctions. And the second reason, I think, again, with the prospects of possible enforcement of such Russian judgment abroad. So say if it was like English court anti-suit injunction to injunct Russian courts from proceedings, and Russian courts ignore it and pass down the judgment. So I think, well, quite definitely this judgment will not be recognized in England. But again, the question is if it can be recognized not in England, here in the Emirates, if it was passed down ignoring English court order. I don't know. Well, Igor, what can you say about this?
Well, it's another question, Maxim, I'm afraid, which we can spend half a day discussing that. 10 minutes. Okay, I'll try to do it in 5. So again, we have this dichotomy of jurisdictions where we have onshore courts and international courts. When we speak about such thing as anti-suit injunction, we can forget about onshore courts. There's no place for recognizing and enforcing something like that in onshore courts here in Dubai and Abu Dhabi. But speaking about international courts, the situation is pretty interesting. And in particular, that might impact the tactics in this anti-suit injunctions wars, where, you know, Russian parties were getting Russian anti-suit injunctions. International parties were getting anti-suit injunctions from English courts, and then they were thinking, oh, what shall we do? What shall we do with these court orders? With the new DIFC law that was passed in 2025, the answer could be that DIFC courts would be the place where these injunctions can meet. The reason for that, if you look at the new DIFC law, in particular article, DIFC courts law, in particular article 31, that says that now DIFC courts, and it's now a part of the law, the DIFC enforcement judge may enforce not only the final judgments on the case, but also interim judgment and orders of foreign courts. That potentially makes various interim reliefs, including injunctions, enforceable by DIFC courts. Speaking about English court judgments, I mean, there's no treaty between the UK and UAE, but following the Linde case, UAE courts are enforcing the judgments of English courts. And with this new provision of law, there's a good prospect of get an English court anti-suit injunction to be enforced in DIFC. What would be the effect of such enforcement or recognition? If English ASI is recognized by a DIFC court, it becomes an order of DIFC court, which means that if later on, if a Russian judgment creditor comes to DIFC court with a Russian judgment obtained in violation of this anti-suit injunction, this will mean that this Russian judgment will be contrary to this order of DIFC court, which is a court of the UAE, because you know DIFC courts are part of the UAE court system. And from practical perspective, that means that this Russian court judgment may not be enforced in the UAE. It's a kind of a direct gateway that cannot be passed in this case. What happens if a Russian claimant will bring its Russian anti-suit injunction to DIFC? Oh, it's a good question. That still remains to be seen, because first of all, I said that procedurally, the gates are open. DIFC courts are now enforcing interim orders of foreign courts. So that could be a starting point. But then there will be a very interesting discussion. And for that purpose, we'll need to look at the nature of these anti-suit injunctions, like English or common law anti-suit injunctions, and the anti-suit injunctions that are given by Russian courts. So if you look like at the classic English anti-suit injunction, what is it? It's an equitable remedy that an English court gives in order to uphold parties' obligations under the contract. So there is a contract, which is an arbitration agreement or jurisdiction agreement. One of the parties is going to breach this contract and go to an inappropriate court. So what the English court is doing is upholding this agreement and giving an injunction to restrain that party to breach the agreement. What happens with the majority of Russian anti-suit injunctions? Russian anti-suit injunction, in the most of the cases, is a sanction of a Russian court to breach the agreement. And that's a very interesting difference. Again, as I say, this is not a universal conclusion. Every case is unique. Every case is fact-intensive. But this, I'm afraid, will be the starting point at which a DIFC court, being a common law court, will look at the Russian anti-suit injunction that will be put in front of it. If you are able to persuade the DIFC court judge that this is not a sanction of the court to breach a contract, but as Oleg said, Russian party is going to a Russian court because the arbitration clause becomes invalid, inoperative, or incapable of being performed.
It's what the Russian court says.
Yes. Then you have something to discuss. If it is not, if it is a sanction to breach a contract, where you have a valid arbitration clause, okay, good luck. Try and persuade the DIFC court judge to give you a court order.
Thank you very much, Igor. So we have some time for your questions. So we have a microphone in our room. Any questions? Okay, well, maybe when I have because it's so you heard now about hundreds of Russian judgments and mostly against foreign companies protecting Russian claimants. But as I know, because we defend mostly Western companies in course, and it's not always the case that Russian claimants. And so my question to Alex, so can you give us like not just examples, but maybe the kind of cases where it's still possible to win for a foreign company against a Russian claimant?
Well, I think they may be classified in the following groups. So first, if there is also a Russian co-defendant, for instance, some payment was blocked, and the claim is filed against all the banks involved in the chain. So against the Russian bank and against the foreign bank. Yeah, and in this case, the courts often dismiss the claims to the Russian bank because they say that there is no fault of the Russian bank in the blocking of the payment, but not necessarily affiliated. That may be just the chain. They say there's no fault of the Russian bank. It didn't block the payment, but at the same time, the claim is also dismissed against the foreign bank because they are in the same position. I think there are also other examples, for instance, where some payment is blocked or some assets are blocked in Russia, and there is a procedure in Russian law how to unblock them. And the claimant, instead of following the procedure or having missed the deadline to comply with the procedure, instead files a claim against the foreign defendant. And in this case, the foreign defendant says, well, sorry, you had a specific remedy, you didn't use this remedy, and that is why your claim is dismissed. So I think there are examples. I think Nikolai has more examples.
Yeah, I will just refer, for example, to the JP Morgan case in the Supreme Court, which our team won recently, where the court supported its previous position on Citibank case, saying that there are, first of all, very significant obstacles with satisfaction of claim to the Russian subsidiaries, and the very strict test should be applied in case of bringing liable the Russian subsidiaries for its parent companies. And also reminded to the courts, lower courts, its own approach of the Supreme Court of 2023 about the need to get an unblocking license, about the absence of tort. So since I will say in 80% of the Russian sanction-related cases, the claimants referred to the tort, and this previous Supreme Court position are very beneficial for the foreign defendants. Also, I will say that sometimes it's not clear whether obligation really exists and whether party A has an obligation before party B, or party B has an obligation before party A, like in a like swap transactions, and in such cases, it's a very big problem for the Russian court to satisfy the claim swiftly, as you know, since it's very easy to say that this was blocking of funds, and this is a clearly not fulfilled obligation because of sanctions, and that's why it should be satisfied. It's very easy for the Russian court. But in case when the relations are quite complicated, and it should be actually proven that initial obligation exists, it's still a good ground for the defendant to protect their position.
Thank you, Nikolai. So maybe to summarize, I think we can draw from this recent Citibank and JP Morgan cases two quite important conclusions. The pattern is quite similar in all these cases. So a Russian claimant brought a claim against a contractual debtor and joined as a co-defendants 2, 3, 4 Russian affiliates of this contractual debtor, and in most of the cases, these affiliates, they had nothing to do with the case, so they're just an affiliated, that's it. And so the court approach was quite unified, that because you are in the same group of companies, that's your fault, and that's you are also liable, and that's enough to hold you liable. But recently, especially with JP Morgan case, it was judgment of the Supreme Court was published 3 weeks ago. So it quite clearly said that two things. So that's first, that just affiliation is not enough. So you should prove that this Russian affiliate is not really independent legal entity, but was used just as a corporate front. So that's why we can violate the basic principle of autonomy of a legal person, only in this case. And second conclusion, that if there is a possibility for a Russian claimant to apply for a foreign regulator license, like OFAC or any other regulator license, to release your assets, and you didn't apply, so it means that the tort has not occurred because you have not exhausted all the ways how to minimize the consequences of the wrongdoing. So it means not complete change in the trend, but it means most likely that the trend will be not as negative towards Western companies as it used to be during a recent couple of years. So that's the finish, and thank you very much for your attention. Thank you very much to my colleagues. Have a good day.